Hi guys, it's Kathy. I hope you're doing well. I got a pro se inmate who wants to speak to the manager. Dude forgets that he's on trial, not everybody else. And you'll see, it's very frustrating. The poor judge. And she's not a judge that has patience of a saint.
This is State of Indiana versus Andrew Rogers. Cause numbers 20D01 2308F61006 and 20D01 2503F571. Mr. Rogers, please raise your right hand to be sworn. Do you swear or affirm under the pains and penalties of perjury the testimony that you provide to this court will be the truth, the whole truth, and nothing but the truth, so help you God?
Oh, yes. All praise be to Allah.
Please tell me your full name.
Andrew Rogers.
Thank you. The court shows that the defendant appears by video from the Elkhart County Correctional Facility as a self-represented litigant. The state of Indiana appears by DPA Anna Rich. And I show that we are here today on the bond report that was filed with the court back on June 10th. Mr. Rogers, did you review that bond report?
Yes, I reviewed that bond report, and I see some about the status conference hearing today also.
Okay.
They said it got, that's what paper I got served, said the status conference. That was on the 23rd originally, got moved to the 16th.
So, Mr. Rogers, the bond hearing or the bond report was filed in the newest case. The other case was just set for a status hearing, just to go along with that bond request that you made in the new case.
Yeah, because there's some issues. It was some things I want to address beside that bond report today also.
Mr. Rogers, you have to put the state on notice. You have to file some type of a pleading that you want to have addressed. Did you file some type of motion?
Yes, I filed a motion to enter evidence with you. I don't know if you received it yet. I filed a motion for deposition, and I filed another motion for dismiss of charges.
Mr. Rogers, we addressed that at the last hearing. I denied your motion to dismiss. I told you that as far as the motion for deposition, you don't have to file a motion. You just have to make arrangements for that deposition. So that's up to you to do that because you have agreed that you've chosen to represent yourself. And the other thing too is that regarding I think the motion you said to admit evidence, is that what you said?
Yes.
That's not how that works either. So once we're in trial, you can move to introduce evidence if you lay an appropriate foundation under the Indiana rules of evidence. But as of now, there's no evidentiary hearing. We have the trial coming up. So there's nothing for me to rule on at this point in time.
Yes, because it never is no law stating that I can't file more than one motion to dismiss.
Okay. I don't see where you filed another motion to dismiss.
You probably haven't received it yet. I sent it out last week. I thought you might would have got it by today. So you should have it in the next couple days.
Okay. I don't have it, Mr. Rogers. I can tell you that you have a final pretrial conference 2 weeks from today's date. If I receive it by then, we can address it, but I don't have that today. The only thing I have on my calendar for us to address today is the bond report that was filed in the newest case. That's it.
Okay. And you said the status conference that got moved from the 23rd to today also.
We just set it for tracking purposes. It's just tracking along with your other case.
Okay, because there's some issues I would like to address about that status conference.
Mr. Rogers, there's nothing to address at this point in time.
Because last court date, you told Colin Groover to give me the evidence, and he never came out here and brought me no evidence. So my right to a fair and equal trial is being violated because he never brought me none of the evidence that that Indiana Criminal Rule 2.5B1 mandates that I get that evidence. I should have got that evidence under Indiana Criminal Rule 2.5B1.
Okay, so are you saying that Mr. Groover never came out to the jail and brought anything?
No, it never brought anything. So my right to a fair and equal trial.
Hang on. I just want to clarify. He didn't come out at all and bring anything. Is that what you're saying?
That's what I'm saying. He didn't come out and bring anything to me. No motion of discovery, no affidavit, nothing. I have no evidence in neither case. And you told him multiple times to bring evidence.
Hang on. Ms. Rich, do you have any record?
Mr. Gruver did bring out evidence to the jail. We were working closely with Tina Kine and Amy Jones, I believe. They have the evidence and they're working right now to arrange someone to sit with Mr. Rogers as he views the discovery, as there has to be additional security measures at the jail. The jail has all of the discovery and they're just working on some of that procedural stuff.
Okay.
Mr. Gruver personally brought out, there was a flash drive that was couriered out, all of our discovery, issued motions, those have been served.
Yeah, but was there a file? Was there a metal file in the file of discovery? Did you put a metal file in there for him? No.
As well, so it's just a matter of those getting to Mr. Rogers through the jail.
And
Mr. Rogers.
I'm sorry.
Did the state receive any type of input or feedback from the jail as to when that's going to be arranged, as he has a trial coming up?
Correct. So we did know that it was time sensitive. They assured us it would be soon, but they didn't give us a specific date. I can look into that because that's something obviously that we want to have happen.
Sure. So it sounds to me, Mr. Rogers, that Mr. Gruver followed through, but there's a procedure. He doesn't meet directly with you. He brings that to jail staff, and then they make arrangements for you to see that. So Ms. Rich is going to follow up on that and impress upon jail staff the importance of making sure that that happens as soon as possible. Okay?
Yeah. Yes.
Okay. So, Mr. Rogers, I will briefly let you say what else you want to address today,
But first, won't you be my neighbor?
but I don't think we're going to be in a position to address whatever it is that you want. But let's just go ahead and hear what you have to say.
I want to speak on that motion that I filed to dismiss, but obviously I probably can't speak on that today, right? Until
You're talking about the one that I don't have and the state doesn't have?
Yes, yes.
That would be correct because I don't have it.
Okay, well, another issue I would like to speak on, because it's right here about the key rules outlined code judicial conduct, about the rule that the judge have to uphold. Judge Christine, after they haven't been upholding the rules and things like that, the state been getting away with doing a lot of stuff. Because I should have been had them evidence that they that you've been asking about, telling them to bring it to me and give it to me, even when we was in court and he told you about it so many hours of what's name evidence, and I have to come down to the prosecutor office to view it, and you told them that wasn't acceptable. I need that evidence. And so I would like to know who is your higher up, who I need to talk to about filing a complaint on the judge under Indiana, under what is it? It's not legal for a judge in Indiana to bend someone to their will, particularly through coercion or improper pressure tactics. Indiana judges are bound by the Indiana Code of Judicial Conduct, which requires them to perform their duties impartially and diligently. And if someone believes a judge is acting improperly or engaging in unethical conduct, they can report it to the appropriate authorities responsible for judicial discipline. So I'd like to know the proper authorities I need to report this to, because I'm not getting treated fairly with going forward with trial.
Okay, so the Code of Judicial Conduct does require that I certainly am impartial. But Mr. Rogers, as I have expressed to you over and over and over again, you are in over your head. You don't know what you're doing. I am not your advocate. I am the judge. And I cannot just issue rulings without you following the proper procedures. And you have certainly voiced your concerns about discovery. I have expressed that you have concerns to the state of Indiana, but as I've told you, at least on one occasion, if not more occasions, you aren't handling it properly. You are not bringing the proper motions to the court for me to do anything further. I don't have any authority to just act on my own against the state of Indiana. And if you're asking me for guidance on how you file a disciplinary complaint against me, figure it out. If you think that I have committed some type of violation of the Code of Judicial Conduct, that is certainly your prerogative. And follow up on that. I'm not telling you not to, but I'm also not going to tell you how to do it either.
No, I'm not asking you how to do it. I was asking you who's the judge in charge of Elkhart County.
There is no judge in charge of Elkhart County.
Okay, all right. I thought it might have. I'm sorry.
You thought it might have been who?
A judge in charge is like, yeah, the head prosecutor. I thought it might have been the head judge. Like Vicky Becker, the
No.
head prosecutor. I thought it might have been the head judge.
Michael Cristofino.
No, we're all independent elected officials.
Okay, all right.
So, Mr. Rogers, I'm going to once again express my concern about you representing yourself. You don't know how to properly deal with these discovery issues, which includes both compelling the state to get you discovery, as well as doing depositions or these other things that you need to do. You are in over your head. Are you certain that you do not want an attorney?
I don't want the oppressor servant to come and represent me.
You don't want a what?
The oppressor servant to come represent me.
Oppressor servant?
Yes, that's what a public defender is. The oppressor servant. They come to oppress me also.
Okay, I just had not heard that term. I just didn't know if I heard you correctly.
I don't know what happened to the screen. I can't see nobody. Okay.
Okay, I didn't do anything that would be on your end.
But Indiana criminal rule mandates that I get the Indiana criminal rule 2.5B1 mandates the state disclose relevant information to the defense within 30 days from the initial hearing or the initial appearance of defense counsel, whichever is later. This is part of the automatic discovery rule, meaning the state must provide this information regardless or whether the defense requests it. The prosecution must disclose a variety of information, including witness names and contact information, witness statements, defendant statements, grand jury. The rule also applies to situations where defendant is representing themselves, meaning the 30-day time frame starts from the defendant initial appearance, the initial hearing.
Rogers, I'm going to interrupt you right now because your initial hearing took place on May 21st. We are not at that 30 days yet.
For the other case, it's been 30 days. It's been longer than 30 days for the other case.
Mr. Rogers, you have not filed a motion to deal with that. You've complained about it, but you've not filed a proper motion. It's not properly before the court.
It's stated in my motion to dismiss. I stated that about.
That's not how you do it. That's not how you do it, Mr. Rogers.
But I stated in my motion to dismiss those grounds for me not getting the proper evidence and things. It's the trial rules and criminal rules to support that evidence in that motion to dismiss.
Okay, it's denied.
Now talk about in the one not the old one, the new one that should be making your way.
Mr. Rogers.
That's gonna be denied too, buddy.
Again, you don't know how to follow criminal procedure. You aren't looking at all of the rules of criminal procedure or the rules of trial procedure. There are things that have to happen before it gets to that point in time where you may be entitled to a dismissal. You haven't followed through with any of those steps yet. We are not there yet. And usually, Mr. Rogers, the remedy is a continuance, not a dismissal. So, Mr. Rogers, we are coming back on June 30th for the final pretrial conference for your trial that is scheduled on July 15th.
Not just this dismissal, Judge. You should also give him $1 million.
So I don't know what else to address at this point in time. Like I told you, the only thing that was before this court is the bond report that was filed in F571. And I think that was probably ordered by the magistrate. However, it's moot because your bond was revoked in F61006. Even if I release you in the new case on your own recognizance, you will be held without bond in F61006. So at this point in time, the court is not inclined to address any type of bond reduction in light of the fact that bond has been revoked in F61006. The other thing that you need to be aware of, Mr. Rogers, is that the state last week filed a motion for joinder. They filed a motion to join the two cases. Did you see that motion?
Yes, I want to speak on that also.
You need to file a written response.
Oh, I can do an oral motion and have it in to you. And before I send the motion in to you, I can file an oral motion that I don't want them have the cases joined combined under Indiana Code
He's filing an oral motion, guys.
35-34-1-12.
Ms. Rich, are you looking up that authority? 35-34-112.
Yes.
It's the severance motion.
Okay, so it doesn't apply. Okay, it does not apply. You're asking, what the code section that you cited is for severance. So that would be if a case involved multiple charges filed together that you would want to separate into separate cases.
Yes.
The state is asking to do the opposite. So the severance doesn't apply because nothing's been joined yet.
Okay. So you haven't acted on that motion, whether you're going to join them or not?
No, because you have the opportunity to be heard on that.
Okay. And do we have a date for that or that's July 30th will get addressed?
June 30th, we will address that.
Yes. So I mean, June 30th. Yes.
And it would be better if you filed a response in writing so that the state had that ahead of time and the court had that ahead of time as far as what legal authority you have to support any type of objection to the motion for joinder.
Okay. Okay. All right. So what about my motion that you received this week to dismiss? Are we going to end up acting on that also?
On June 30th, and I have not received it yet.
Okay. And so they're going to make a date where I can see all the evidence and I can have that in my possession, the motion of discovery and everything, right?
I don't know what the rules are at the jail, and I'm not going to tell you how exactly that's going to happen, other than I'm aware of the fact that arrangements are to be made for a jail staff person to sit with you and view those discovery materials, and you won't be able to keep that on you because that would be a violation of just safety policy at the jail, but you will be shown that.
I'm talking about the paperwork, the motion of discovery, the paperwork, not the hard drive, anything like that. I'm talking about the paperwork.
Mr. Rogers, I have no idea what the discovery consists of. I don't get discovery. I see none of that. So I don't know what any of that is. And I don't know if anything will be printed out for you. That's a discussion you'll have to have with jail staff.
So even if that DVD I had submitted to them, that was one thing I put in my motion to enter evidence with that DVD. That's what I want entered into evidence within my motion I had wrote.
It means nothing to me though, Mr. Rogers, because I'm not the trier of fact here. The jury is the trier of fact. And if you are able to lay the foundation to get that in front of the jury and admit that, you will do that at the trial in front of the jury, again, who is the trier of fact. Because it doesn't, even if I looked at it for any type of motion to dismiss, I would not have the legal authority to dismiss your case. It's, as I've told you over and over again, Mr. Rogers, you and the state just disagree on what the evidence is. And so the way that you handle that when you disagree on what the facts are, you bring it to the jury and let the jury decide. That's what's happening here on July 15th.
So I also want to
That's crazy talk, Judge. You just have to dismiss everything. Now remember, he's the one on trial here. He's the one going to trial for domestic violence, among other things. There's a couple different cases that he has floating around. I know you don't know that because he's not talking about that at all. He's just talking about everybody else being a criminal, but he's the one on trial for something completely that has nothing to do with anything he's saying here.
I'm gonna file a motion for a fact-finding hearing because since I got a 30-day, I got a fast and speedy, I'm entitled to a fact-finding hearing.
That's something I've never heard that request before, Mr. Rogers.
I got it written down.
So what's your authority for that?
Yeah, I got so many paperwork right here, different Indiana code. I'm gonna pull it up right now.
You need a binder, sir. Maybe two.
Ms. Rich, do you have any idea what he's referring to?
Yeah, okay, yeah, okay, I'm ready. I found it. It says a defendant in a criminal trial.
Hey, hang on a sec. And I apologize. What are you referencing? Are you referencing a statute or a criminal rule or trial rule?
Criminal trial in Indiana generally has a fact-finding, has a right to a fact-finding hearing, especially if they deny the charges against them. This is a right often associated with a speedy trial, ensuring a fair and timely process.
Okay, but what's the authority for that?
Yeah, I think I left that paper, the authority under it. I think I left that back on the unit. It was. I told them to let me know when it was coming because I was getting all my paperwork together, and they just came on a drop of dime to get me while I was sorting things out because I be sitting down and doing all this work myself. So it ain't just easy just going through the paperwork and grabbing everything I need.
Ms. Rich, you are still looking to see if you can figure out what.
Yeah, it's not criminal for, when I look up election cases.
That's exactly what I'm seeing in Shin's cases.
He's primarily juvenile law.
I think it is too. Mr. Rogers, I have no reference for what you're talking about, other than I'm aware that it's something that happens in child in need of services cases. I have yet to see any type of fact-finding hearing in a criminal case that you're talking about. So you're going to have to show some type of authority for what you're referencing.
Okay, another one I was going to reference to is the evidentiary hearing also are governed by Indiana Code 4-21.5-3-26, which outlined the conduct of a hearing and the admissibility of evidence.
I'm guessing that would be a motion to suppress. We would have an evidentiary hearing, but I don't have such a motion in front of me.
Yeah, I'm making an oral motion, and you'll have the physical motion this week or beginning of next week. It will definitely be in.
What are you talking about?
For the evidentiary hearing.
It's an administrative law. It's not criminal law.
Okay, yeah, when you referenced Title IV.
It's talking about adjudicative proceedings under state offices and administration.
Okay, Mr. Rogers, I don't think that it applies to what you're talking about.
The Indiana code that I gave you?
Yes, because the code section, it's under Title IV. That's the administrative code. That's not the criminal code.
Okay, so I wrote the wrong one down. Okay, I had that fixed. As long as I made that on the record that I want an evidentiary hearing, that's on the record. I can get you the right paperwork in the right code.
Mr. Rogers, an evidentiary hearing for what?
The evidence that they supposedly have or whatever.
You have that hearing. It's a jury trial on July 15th. You have that hearing. That's what you do at a trial.
Okay, is Colin Groover still on this case?
I don't know. I'm not in charge of him.
Because
He also filed a motion to submit evidence in court. It's going to be a great trial, guys. This is going to be great. Wait till you hear why he wants this Groover guy. I just can't. I can't.
see, we got a different prosecutor right now that's speaking right now. So I want to know if he's still on this case also.
I don't know, and it's really irrelevant.
No, because I got a lot of things I'm going to ask everybody in trial. I'm not just going to ask Lorraine Payne and all the other witnesses y'all subpoena. I got a lot of questions for Colin Groover about our conversation.
You don't get to ask him questions in a trial.
I'm going to though, because I got the right to tell it.
Mr. Rogers, you aren't. And here's the thing. If I can't control your behavior in front of the jury, you risk being removed from the courtroom and then you have nobody. You cannot in a jury trial ask opposing counsel questions unless you're asking for clarification or of something outside of the presence of the jury, not as any type of evidence. He's not a witness.
From our conversations we had, he is a witness. From our meetings we had,
he's not listening. And listen, I don't want anything bad to happen to this man. I don't. I have no ill will feelings towards him at all. This is just academic. I would like to see him removed from the courtroom because he has no lawyer. And then the trial goes on with just the prosecution, which sort of happened with Darrell Brooks, right? He got removed and there was no one left on his side. But again, he wants to call the prosecutor as a witness to his domestic violence court case. Does that make sense? Now, he's trying to put the court on trial during his trial. Judge ain't gonna allow it. She is not going to, and she's not one you mess with. You just, maybe he should watch Court Vibes more often to realize that he's really going to jail. He's going to go to jail, and nothing is going to stop this train from pulling right into the jail station.
As a witness now, and the things he have said will makes him a witness to the case. Yes, I'm here to tell the truth and nothing but the truth. I'm not here to tell no white lies. I'm here to tell the dark truth, the black truth, however you want to word it. I'm going to tell the truth. So whatever happens, all praise be to the merciful Allah. So he's in control of my life and my destiny at the end of the day, and whatever he want me to go through and things he want me to be out of life, I'm willing to accept that. But I'm standing up for myself, and I gotta tell the truth. Everything that transpired with this case, from y'all not giving me a fair shake, y'all you not upholding the judicial procedure that you got sworn in to uphold. It's a lot of things I want to discuss. So however trial goes, it's however it goes. But as long as I got it on the record that I'm stating these things, that if I do get found that guilty and I need to appeal it, and the appellate court would know all the things is on the record that me stating. As long as it's on the record, that's all I need. Everything on the record.
Mr. Rogers, I'm going to issue you a warning, and I'm trying to do this to help you, whether you believe it or not. Mr. Rogers, I expect that when we go to jury trial, which is, again, that's how we get these disputes resolved. I don't know what the facts are. I know what the allegations are. I don't know what the facts are. And again, it doesn't matter to me because I am not the fact finder. The jury is the fact finder. It is up to them to determine whether or not the state has met its burden of proof and prove you guilty beyond a reasonable doubt. They will be the ones to make that decision. But in doing that, if you violate any orders of the court, if there are outbursts, if you don't follow my directives as far as when it would be appropriate to speak and not speak, then I will have the option of removing you from the courtroom. It's not ideal. I don't know how we're going to contain this. I don't want to have to get to that point where I'm having to make a difficult decision on how to handle this, because I want you to have your day in court, Mr. Rogers. Preferably, I would like for you to have that day in court with an attorney representing you, but you have been very clear that you don't want that, so that's okay. I can't force you to have an attorney. But what I can expect you to do, Mr. Rogers, and what you will do is you will follow the rules of decorum, meaning that you are going to be respectful and polite. You are also not going to talk out of turn when it's not appropriate for you to talk. You are not going to have any outbursts or interruptions. You just aren't, Mr. Rogers, because if you do, I will have to handle it in whatever way that I see fit to do that. I don't want to interrupt those proceedings. I want you to have your day in court. You're just making it very challenging for the court to do that.
Well, anybody else? As long as I say objection, I can object to anything the prosecutor is saying that I disagree with.
If you haven't, well, it's not just if you disagree, you have to raise an objection based upon the rules of evidence. So for instance, if you believe that the state is introducing evidence that is not admissible because it's hearsay, you would have to object that it's hearsay, and then I will hear an argument. And to be clear, the arguments are going to be made in front of the jury. So I will allow you to make the arguments to me and determine whether or not the evidence is admissible or not admissible. But you absolutely can object to evidence that you think, based upon the rules of evidence, is not properly being admitted.
Because I feel like you already tried to bend me to your will when that time, when I told you I wanted to go pro se, you didn't like the way I was answering the questions. You tried to dangle 30 days of contempt of court over my head. And in the next court date, you were going to decide whether what happened depends on how I answer questions and stuff like that. I felt that you were trying to bend me to your will and talk how you want me to talk and things like that, and not give me a voice like Allah have given me.
Mr. Rogers, I will be clear with you, I guess to the extent, and you can characterize it however you want. I expect that you are going to follow the rules of procedure and that you are going to follow the rules of decorum, meaning being respectful. And when you are not listening to what the court is saying, and the same would be true for the prosecutors if they did the same thing, that I have that mechanism, that contempt mechanism, to try to get your behavior back to where it should be, where you are not speaking out of turn or not speaking in a disrespectful tone. Because if, I will be clear, if the state talked to me the way that you have talked to me on some occasions, Ms. Rich or Mr. Groover would likely be in jail. I don't like to give out contempt sanctions heavy-handedly. My goal is to just try to just get you to follow the rules. And as long as you follow the rules,
Tase him.
I don't necessarily have to agree with what you are saying. You just have to follow the rules.
I never broke no rules in court. I never called nobody out their name or disrespected nobody.
Mr. Rogers, this conversation is not going anywhere. I'm not saying that you necessarily called somebody a name. I don't remember specifically what the issue was back then, but we're past that, okay? However, it's subject to be revisited later depending upon how things go in front of the jury, because a lot of these back and forths that we've had would not be good for you to do in front of the jury. And I'm most concerned about the prejudicial effect that that could have against you, Mr. Rogers. I don't think it's going to be perceived by the jury very well if this is how you behave in front of the jury. But you can choose to act that way to your detriment. But again, I expect people are going to be respectful to each other, just like I expect the state to be respectful to you, and I expect you to be respectful to the state. I expect rules of procedure and rules of evidence to be followed, and any other applicable rules. I just expect them to be followed, period.
How you expect the rules of evidence to be followed, and it took them this long for me to get the evidence, for me to review evidence?
Mr. Rogers, I'm done talking in circles. There's nothing else for us to address today. We'll come back on June 30th, and at that point in time, we will discuss the state's motion for joinder. And I believe that the state also filed a motion to amend the charging information. I believe that there was a request to add it was another count of domestic battery, but it was an alternative theory. Is that accurate, Ms. Rich?
That's correct, Your Honor, and I do expect that we'll have a motion in limine. I will make sure we get that filed before the next court date as well.
That would be a good idea.
So
there's a lot to discuss. I don't know how we are.
So you're saying you're not going to dismiss my case? Judge, can we move back to the dismissal, Judge?
We'll have to look at that. We may, depending on whether or not our trial goes out next week, we may want to revisit that. So Mr. Rogers, What Ms. Rich is saying is that we have a lot of things to discuss at our final pretrial conference, and doing that on a regular Monday might be difficult just because we want to make sure that we have enough time set aside to hear the matters. Just be on the lookout for maybe setting another hearing for next week sometime to address that. And I'm looking maybe at
Judge,
Thursday.
he has to check his calendar first. You didn't even give him a chance to check his calendar. What if he's busy? What if he can't make it that day?
The 26th in the morning. So that might be an option, but we'll let you know, Mr. Rogers.
I got a quick question about the amended thing. Would they add a charge or they dropping the charge? I don't understand what y'all was saying about the amending. I know what amended mean, but I don't know if y'all adding a charge or changing
So
the charge.
let's be clear. I'm not with the state of Indiana. I didn't do anything other than we received the state's motion for leave to amend. I had asked Ms. Rich for clarification, and she said the state they want to add a charge of domestic battery as an alternative theory, which is explained in their motion for leave to amend. Have you received that yet?
They so slow doing things.
So the question is, did you receive their motion yet?
No, I haven't received that motion. No.
Okay, so once you receive their motion, it explains what they're wanting to do. And on June 30th, or whenever we have the final pretrial hearing, we'll have a further discussion on whether or not I should grant that motion. But you have the opportunity to be heard from on that.
Okay, so I can't talk about no other motion about dismissing until you get the motion I filed, right?
That is correct.
Okay, and only way to get the bond rest, I have to file a motion about my bond. Okay.
Exactly.
Okay, I just wanted to make sure we all on the same page.
Yeah, we are definitely not all on the same page, sir. You are not even in the same book. Yeah, so that was all about his domestic violence charge. No, it wasn't. This trial is going to be crazy. And I don't know exactly when the trial is. I know they threw around some dates during this hearing, but that's sort of not how it works in Elkhart. And it's like this everywhere, but there's like 3 or 4 trials set for that same day. And they take the trial. So if you're out of custody, you get bumped to the bottom of the list. He is in custody. However, he's not exactly in custody for this case. He is and he isn't. All right. She didn't address his bond because he's in custody on a completely different case. And there's a no bond on that one. So he can't get out of custody, but that's because of the other case. All right. So if you're out of custody, there's 3 trials that day. Or this is just an example. So let's just say there's 3 trials set for that day. All right. The first trial is someone in custody for the case that is about to go to trial. The second person is someone in custody for a different case, but still in custody. And the third is someone who is not in custody. Okay. Well, the one not in custody, he gets bumped to the bottom. So chances of his trial going that day are lower. The second one is the one who is in custody, but not for that case. He gets bumped down. The first one is someone who is in custody for that case. They go to trial that day. Also, though, there's another caveat, the age of the case. So if you have someone whose case is 2 years old and someone whose case is 1 month old, the case that's 2 years old is going to trial that day. They want that case out of there. The case that's 1 month old, they wait. They get continued. They don't get no trial. So that's what I mean when I say I don't know when his trial is going to be. Who knows? Right now it's set for, I think, July 13th, which is, less than a month away. She does not stream every day. So it's not like I can just watch her court every day to see when he flies by. She only streams sometimes. But I'm going to do my best. She either streams and I get it, or she doesn't stream and I don't get it. That's just the way life goes, you know? If you really want to see that bad and you don't want me to miss it, then you're going to have to travel to Indiana and sit in her courtroom, which would be wicked cool. Actually, we have a Viber that's going to be in her courtroom, which is wicked cool. Anyway, thank you guys for coming out to see the video. I do appreciate it. I know Replay Crew, you can't get to the 4:30 streams. It's just too early. You are just sleeping, and I love sleep, and I love the fact that you get to sleep. But I want you to know that you are equally important to me as the live streamers. So I'm trying to put out more videos just for you. Yeah, the live streamers, they can get it secondhand like you guys have to. I do appreciate you all, though, so much. I hope you have a great day, and I'll see you again real soon. Bye, guys. Thanks.